In the past, it's been used by the media to interpret falsely the content of conversations between Mr. Robinson and his lawyers, and it happened again just while the court was in session. I have the clip, and I'd like the court to look at it to see if I'm correct, because I think the court will see they're zooming in on Mr. Robinson's lips, and it's going to allow the media to offer these same sort of false narratives they have in the past.
The camera
so the
zoomed
court's
in.
permission.
9 seconds. That's all it took. No gun, no witness, no confession, just lips moving. A silent exchange between a defendant and his lawyer, captured, framed, and sent into the world. And in those 9 seconds, a courtroom tensed. The defense stood up. The media was warned. And a judge did something rare. He intervened. Not tomorrow, not after trial, but right then. Because what was filmed wasn't evidence. It wasn't testimony. It was
the violation. The violation comes from the camera, the pool camera providing live feed. It doesn't come from the photographer. The photographer is the still, I don't know what the exact term is in this moment, it is eluding me, but the person who's operating the camera to take still shots is under the same requirements for this decorum order. I am not going to sanction them because what was before me with the 9-second clip and the 5-second clip doesn't apply to them. And so I'm going to limit the sanction as it relates to the pool camera photographer, again recognizing that the standing decorum order applies equally to the still camera photographer.
A glance,
Thank
a
you.
whisper without sound, a moment never meant for the public. This isn't about what Tyler Robinson said. No one actually knows that. It's about who decided they could decode it, who turns silence into narrative, and what happens when justice is no longer weighed by facts, but by a camera that refuses to look away. This case doesn't begin with a crime scene. It doesn't begin with police tape. It doesn't begin with a 911 call. It begins with a camera lens. Because inside a Utah courtroom, something small happened. Something quiet. Something easy to miss. And subtle things are the most dangerous. A defendant leaned toward his lawyer. Not dramatically. Not urgently. Just close enough to speak privately. No audio. No transcript. No official record. Just motion. Lips moving. To the untrained eye, it meant nothing. A routine moment. An everyday exchange between attorney and client. But to the media, it meant everything. Because in the modern true crime era, silence is no longer empty. Silence gets interpreted, analyzed, slowed down frame by frame, enhanced, speculated on. Silence becomes content. And sometimes, silence gets weaponized. Tyler Robinson sat at counsel's table, not convicted, not proven guilty, not even on trial yet. A man presumed innocent, a man awaiting trial. A man whose fate was supposed to be decided by evidence, by testimony, by exhibits, by facts presented under oath, not by expression. But expression is irresistible to cameras, because expression feels revealing, because expression feels honest, because expression feels like truth. A raised eyebrow, a slight smile, a moment of frustration, a whispered exchange. None of it evidence, all of it powerful. Defense attorney Michael Burke stood up. He didn't rush. He didn't raise his voice. He didn't accuse recklessly. Calm, controlled, measured, but unmistakably alarmed. He told the court something had happened again. Not alleged, not speculative, not hypothetical. Again, the cameraman, he said, had violated the court's standing decorum order, not by recording sound, not by broadcasting confidential audio, but by recording lips, zoomed in, focused, held, lingering long enough for interpretation, long enough for someone, somewhere, to claim they knew what was being said. And that claim, true or false, would not stay contained. Because once an interpretation exists, it spreads. And this wasn't paranoia, because it had already happened before. The defense explained that in a prior incident, media outlets had taken similar footage, silent footage just like this. They hired a lip reader, a professional interpreter of mouths and motion, someone willing to turn silence into words, and they published the interpretation, not as speculation, not as possibility, but as implication, words assigned to a defendant who never spoke them publicly, an interpretation that implied guilt, not proven guilt, not courtroom-tested guilt, not evidence-based guilt, narrative guilt. And once a narrative escapes into the public, you cannot pull it back. You can object, you can clarify, you can deny, but you can't erase, because people remember impressions, not footnotes. The defense asked the court for something extraordinary. Not later, not after trial, not after damage. Now, either remove cameras entirely from the hearing or stop them from showing Tyler Robinson at all, because his face, his reactions, his private communications with counsel had nothing to do with the truth of the case. Only the spectacle of it, only the performance of it, only the version of justice designed to be watched. The judge listened, not impatiently, not dismissively, carefully. The court reviewed two clips, 9 seconds, 5 seconds, 14 seconds total. 14 seconds that triggered a constitutional concern. 14 seconds that forced the court to confront a modern problem with ancient consequences. The judge watched carefully, not as a lip reader, not as a media critic, but as a gatekeeper. He noted something important. These were not passing shots, not a quick pan, not an accidental frame. They were focused, deliberate, held. The camera didn't drift. It stayed. Enough time, the judge said, for interpretation. And interpretation is where damage begins. The decorum order was clear. No visual recording of lips, so as to be decipherable by a lip reader. During attorney-client conferences, not zooming, not framing, not lingering. No decoding the defense, because attorney-client privilege is not optional. It is foundational. The media responded quickly. Their attorney stood and acknowledged the concern, acknowledged the order, acknowledged the seriousness, acknowledged that the issue mattered, but denied a violation.
There should have been what I'll just call a referral to the Attorney General's office for this particular motion. I can stand here and I can give the court case names and numbers and sections from the ABA standards, but it was not our goal to, of course, put the court on the spot and require the court to, like, go back into chambers, think about it for, some pressured period of time and come back out and make a decision. So if it would benefit the court for us to file something, and I don't mean in a month, I mean very soon, so that the court has thoughtfully presented points and authorities, we're happy to do that. As far as I know, the only people who've traveled out of town for this hearing are Mr. Burt and myself. So I'm thinking about the convenience of witnesses and the court and counsel. It's important that we do this in a way where the court has the opportunity to make a thoughtful, reasoned decision, as Your Honor always says. So that would be our proposal, is that if the court is open to receiving authorities, that we recess this hearing for, whatever meets the court's schedule, whether it's a week or 2 weeks or a few days, and we can provide the court with something, and we'll come back. But we do think this is a serious issue, because I think the question of who litigates this issue on behalf of the state is in itself wrapped up in this conflict. And we want everybody to get this right.
Thank you.
Once.
My question for you is, knowing this, why didn't you file a motion prior to today's hearing, knowing that the court would be in this position based off your request to prepare the court, prepare opposing parties, and to be efficient in our use of time? I'm trying to understand. I understand what you're saying, and I understand that things evolve, but I'm trying to understand why that wasn't filed in advance of the hearing to put the court on notice at the very minimum, and just to allow the court to do what the court does.
I hear what the court's saying, and I think we can take responsibility for not sufficiently presenting the authorities that we think compel what I've just suggested should happen. We noted in our reply brief that the county attorney should not be representing themselves, and that's probably an inadequate message to the court. But we did file a motion to disqualify, and inherent in a motion to disqualify based on the conflict of interest, we anticipated would be that the state attorneys would seek representation from a clearly non-conflicted, appropriate prosecutorial authority, which, as I've done further research, and Mr. Byrd and Ms. Visser and Ms. Nestor and I have all done further research literally up until earlier this morning, we think it's pretty clear that this court has the authority to make that, I'm going to call it a referral. I think it's an order referring it to the Attorney General if the Utah County attorneys choose not to do so. And the additional information, which we did receive today, I'll just tell you that, was that there had not been any communication between the county attorneys and the Attorney General's office concerning this issue. So I'll fall on my sword if the court thinks I should be sanctioned for not bringing this up sooner. I hear the court, but we are we're juggling many aspects of this case all at the same time, some of which the court is aware of, some of which the court probably is not aware of, but the court can imagine.
No, and I appreciate that. It's not the intent to sanction you. I understand that issues come up, and there's a lot going on, and so the court appreciates your candor and representation today. So these items can evolve, and so the court is not finding fault with you. It's just hoping that as it requires a lot of time and resources for you and for fellow attorneys and for the opposing party and for other parties, we just might want to make sure we make the best use of our time when we're together.
I hear everything the court is saying. I take it to heart. I understand what the court's saying, and we are cognizant of the time that the court devotes to preparation for these hearings. So that's all I can really say.
Sure, and also for Mr. Robinson himself and the victim representative, Ms. Kirk as well. We just want to do our best, and I understand, and I'm not finding fault with you, sir, or your team. We've all been in court. We all know what happened, so I understand. I'll turn to the state. Oh, and I'm sorry, is there anything further that you wish to represent?
No, I could provide the court with more citations, but I'm just wondering if that's really the best way to give the court a list of verbal citations. I think with all consideration for, and we probably have, with all consideration for the fact that the court wants to be thorough and careful, and we do as well. We don't want to shoot from the hip, but I think that we just decided that this was something that we needed to bring to the court's attention in a much more fulsome way once we understood not only the way this was developing, but, frankly, the way the Utah Supreme Court, the ABA guidelines, courts of appeals subsequent to State v. Jimenez, and the information that we received today from the Attorney General's office, which isn't a secret. It's just we had a conversation and we learned that there hadn't been any consultation. If there had been consultation and the Attorney General had said, no, we think you're good to go, then that would be different. And that's what we learned this morning.
All right. Well, I'll go ahead and take those authorities right now if you'd like to list them. Court is ready.
So the
They
second one,
argued the clips were short, brief, momentary, inadvertent, and intentional. They emphasized the length, 14 seconds total, as if time alone determines harm. They argued that excluding cameras entirely would be disproportionate, that Tyler Robinson, as the defendant, was a critical figure, that cameras are allowed, that openness matters, that public access protects democracy, and that restricting coverage could chill transparency. It was a familiar argument. Open courts versus fair trials, public access versus private rights, transparency versus prejudice, and sitting in the middle of it all, silent, observed, interpreted, a man whose freedom was at stake. The defense fired back. This wasn't the first apology. This wasn't the first assurance. This wasn't the first promise that it wouldn't happen again. They reminded the court what happened last time, how lip-reading interpretations had gone public, how they were still online, how they had been shared, clipped, commented on, reposted, how the damage was irreversible. They cited another high-profile case, a case where similar violations forced a judge to take drastic action to ban coverage of a defendant's face entirely, not because the media wanted to harm, but because harm had already occurred. The defense said something chilling, that when Tyler Robinson smiled briefly at his lawyer, a human reaction, a fleeting moment, media commentary twisted it into proof of remorselessness. A smile became a verdict. A facial expression became character evidence. That's the danger. Not lies, but interpretation without context. The judge took a pause. The courtroom waited, and then something critical happened. He ruled. He found a violation. Not ambiguous, not borderline, not debatable. A violation. Paragraph 48 of the Standing Decorum Order had been breached. The judge acknowledged the gravity of sanctions available: fines, jail time, contempt, real consequences. But he declined them, not because the violation didn't matter, but because punishment must be proportionate. Justice, even when correcting itself, must remain measured. Instead, the court chose something surgical, targeted, immediate, contained. For the remainder of the hearing, the camera would not show Tyler Robinson at all. No sweeping shots, no close-ups, no reactions, nothing. The camera would point only at the bench, the lectern, the process, not the person. The cameraman was called forward, not to shame him, not to threaten him, but to ensure compliance. Could it be done? Could the camera operate without centering the defendant? Yes, the camera stayed put. The judge made it unmistakably clear. One more slip, and consequences would escalate. Still photographers were discussed next. The defense wanted them restricted to. They argued the same harm applies. A single frame can become a headline. A frozen expression can become a narrative. A moment can outlive context. But the judge declined. Why? Because the violation before him came from video, and sanctions must be narrow, tailored, precise. Punishment cannot exceed proof. The decorum order still applied to everyone. Still, photographers were not exempt. But the court would not sanction
Appreciate that.
what had not been shown.
You may approach, yes.
Here are two videos. That one.
What is the length of the first video?
9 seconds.
And do you want the benefit of the record to articulate what this first clip shows?
You know, I think the clip shows that the camera is zooming in the first clip on Mr. Robinson's lips as he is trying to communicate with me sitting next to him.
Thank you.
If I may reapproach with the second video you're on.
Yes.
This one is 5 seconds.
It looks like.
And Your Honor, the second video is a clip from a court TV posting showing Mr. Robinson's lips moving as he's attempting to speak to Ms. Nestor. And Your Honor, one last thing I'd like to add if I could, which is I think the court very correctly and very cautiously admonished the cameraman about your December 23rd order before this hearing began. And he said he understood the order, and I think the order is very clear as to this lip reader provision. And I can elaborate further why it's damaging, but I think it's obvious to the court if the media is allowed to interpret the conversations between counsel and his lawyer, it creates all sorts of problems in terms of Mr. Robinson's right to a fair trial.
Thank you, Mr. Burke.
Thank you.
And just one more question. I apologize. Just for the benefit of the record, from your position, citing to the standing decorum order, the violation itself, so we can connect it all from your arguments.
Yes, Your Honor, I forget the paragraph, but there is a paragraph in the court's latest December 23rd decorum order.
It's paragraph 48.
48. And it's been a feature of every decorum order. I think we're on the third one. But from the start, the court has prohibited zoom-ins to allow lip readers to interpret what's being said between counsel and the defendant.
And finally, I think you led with this in regards to the sanctions being requested. You cited to the court sanctions, and then there was a second one referring to, and I want to make sure I wrote it down right, because
Sure.
something along the lines of not showing Mr. Robinson at all? I want to make sure I understood that request.
Sure, the request was either to exclude the cameras for purposes of this hearing in its entirety because of the violation and because we can't be assured that the cameraman's going to comply with the court's order. The second request is if the court is not going to exclude the cameras, then it should, at the very least, order the cameraman not to shoot any footage of Mr. Robinson, that the camera should be focused on the court and the witnesses if the court permits that, but it should not be zooming in on Mr. Robinson. His demeanor, his conversations with his lawyers have nothing to do with the newsworthiness of this case. And what it's allowing is very prejudicial information to be leaked to the public through these lip readers and body language interpreters, and it's creating massive prejudicial publicity for us. So that's the request.
Thank you, Mr. Burt.
Thank you.
I'll hear from other parties if they wish to be heard.
Yes, Your Honor. Michael Judd on behalf of the media entities. I want to take the court back to that specific paragraph of the decorum order because I do want to make sure we're on the same page about this. It's the second sentence of paragraph 48 of the decorum order that I understand is at issue here. It does say no visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel, at counsel tables, or bench conferences with the judge. The zoom in language that you have heard referred to previously doesn't fall in that sentence. The zoom in language comes in the next sentence, which says no one may zoom in on anything on counsel's table or the bench to identify any writing. So those are two separate things. The first that we learned about this was during the break. I briefly reviewed the two videos that the court has reviewed. I understand that those were 9 seconds and 5 seconds long. I identified the provision of the decorum order that I believe applied here, spoke to the pool cameraman about that, ensured that the rule about capturing conversations involving counsel at counsel's table or at the bench so that they may be decipherable by lip readers was an important provision in the court's decorum order, that it should be followed. I understand that the cameraman understands that rule, that any capture of those conversations was inadvertent. I understand the concerns raised by defense in this case about potential prejudicial effect of something that is intended to capture conversations. I don't believe that that's what occurred in this case. I believe that the court's order should be understood and applied as written and done so strictly. But I don't believe that there's been a violation here. We've been now on the record for 3 hours. I believe that the total length of the two videos that were shown to the court were 14 seconds long. Whether or not either of those conversations rises to the level of capturing the movement of somebody's lips so that it can be decipherable from a lip reader, I'm not in a position to judge. But I can assure the court that the media is aware of that provision, of defense's concern about the potential violation of that order, and that they will take that seriously. That's already been raised, already been discussed. As far as the remedy sought here, I think that excluding all cameras from the courtroom for this important part of this important proceeding would be broader than any sort of remedy would be necessary here, as would the direction that the cameras not show Mr. Robinson in any way. I understand that potentially any shot on a still camera, on a video camera of a defendant in a criminal case could potentially be twisted or used by some to try to impute some sort of thought or some sort of idea. But I don't believe there's anything in the court's rules. I don't believe there's anything in the ruling so far to date that suggests that the way to address that kind of concern is to say that a defendant, a critical figure in a case like this, and one that the decorum order clearly allows to be photographed and videoed, be kept off camera altogether. The media continues to take this seriously. Before every single hearing, we speak about the decorum order and what it requires. We recognize the importance of doing it and that there can be consequences if that's not kept. The media understands and hears that and do not believe that any further reprimand or any sort of further exclusion is necessary here.
Thank you. But before I turn to you, I want to turn to the stage. I want to give all parties an opportunity, and then that allows you to respond to whatever they say.
Your Honor, we have nothing to add. We'll submit the issue.
All right, Mr. Burns.
Judge, the problem with that explanation, that's the same thing they said last time on December 11th. And on December 11th, there was a same violation. Lip reader, I can pull up for the court what the electronic media did with the prior violation. They hired a lip reader. The lip reader purported to derive a confession from the incident, and they posted that. It's still up there. So it's great that they apologize, but once this kind of damage is done, it is irreparable. And we can't continuously have violations where the media gets up and does this mea culpa, and they just continue to do the same thing. And I point out to the court, this is the same pattern that happened in the Kohlberger case that's discussed in the motion we filed today. And eventually the court there had to order that all coverage of Mr. Kohlberger's face was prohibited. And we attached that order to the motion that was just filed with the court. And I understand the media's desire for dramatic coverage. I understand how they want to incriminate Mr. Robinson. But that process is supposed to happen in a trial, not in the media. And it's a serious violation. It's one that the court should not just blink away and say, I accept the apology, especially after the court was so clear this morning. Calling the cameraman up, asking if he had read the December 23rd order, and his response was, I'm good to go. Meaning he had read it, and presumably he read that provision about zooming in on lips. There's no excuse for it. The court should take some action.
Thank you, Mr.
Thank you.
Anything further from any of the parties before this court makes a ruling on this issue that's before it?
No.
I just want to make one note, Your Honor. Those clips that I showed you are just small portions of much longer footage that was available in the live stream. That was just what we needed to compartmentalize to get it to Your Honor, but it was a much more extensive period of time.
All right. All right, I appreciate this being brought promptly to the court's attention. This is an important issue, and the court takes it very seriously. As it relates to today, well, first, I did put on the record very clearly that there would be potential consequences for any violation of the court's December 23rd, 2025 standing decorum order. For the first part, well, and I've also had a chance to view the two clips that was presented. It was shown to all parties. The first appeared to show an attorney and Mr. Robinson speaking for about 9 seconds is what my memory tells me, reminds me. The second clip was for about 5 seconds. I believe it was from a slightly different angle, but it also captured that. And in both instances, I could see Mr. Robinson's lips moving. And I don't remember about the second clip, but I believe in the first clip, it also showed counsel's lips moving. But notwithstanding, that was in place. I also refer to the statement made by the counsel for the news media, and going to, it is paragraph 48, and I will read it in its entirety. No audio recording is permitted of the conference involving counsel at counsel's tables or during bench conferences with the judge. No visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel at counsel's table or bench conferences with the judge. No one may zoom in on anything on counsel's tables or the bench to identify any writings. Now, in regards to the zooming, I know there was a representation, and it's easy to, as you're reading, to kind of combine it, but I'm not finding that zooming in relates to the lip reader portion, but that's not material. I do find that, and I'm not a lip reader, so I don't know what the standard is for lip reading, but I do note that 9 seconds in that first clip, one could see his lips moving, and it is a significant time for as it relates to this particular issue. It wasn't a passing shot. It was focused on these two persons. And so I find that the decorum order as it relates to paragraph 48, as it relates to no visual recording is permitted of a person's lips so as to be decipherable by a lip reader, I find that that has been violated. In regards to the second clip, 5 seconds, where it shows Mr. Robinson and I believe one of counsel, that I was able to view Mr. Robinson's lips moving. It wasn't a passing shot that it just so happened to capture. It was focused on them. I find that that is a violation of paragraph 48 as it relates to no visual recording is permitted of a person's lips so as to be decipherable by a lip reader. Turning to the next section, finding that the violations have been shown as the court has reviewed the purported evidence of these two violations, I turn to the sanctions. Previously, I stated that under Utah Code Section 78B-6-310, if the court finds a person guilty of contempt, the court may impose a fine of up to $1,000, order incarceration in the county jail for up to 30 days, or both. I find that applying this sanction would be disproportionate to what the conduct was in those two clips. And the court notes that it is the court's discretion on whether to apply it or not. I find that the court will not issue this sanction. In addition, the other sanctions, the court stated earlier today, in addition, the court may impose the following remedial measures if warranted. Immediate suspension of video transmission of the hearing, with proceedings continue only on an audio-only basis for this proceeding where the violation occurred, and disqualification, if necessary and narrowly tailored, of the news organization that filed the request in order for the electronic media coverage of the court proceedings for the hearing in which the violation occurred from providing pool camera operator services in this matter where the court determines such a measure is required to ensure compliance with the standing decorum order and protect the rights of the parties. The court also stated that before making a decision, it would allow counsel to make argument or statements, in which the court has done, and that the court's actions are not intended to have a chilling effect on the open and transparent courts or on responsible news gathering, and that the court is fully committed to the presumption of open proceedings under the applicable rules. That being stated, and as the court was listening, Mr. Burt has suggested that one of the potential sanctions is that for the camera for the remainder of the hearing, and not to show Mr. Robinson at all as a sanction for the remainder of today's hearing. And so the court considered that as well. This court does not wish to make a disproportionate decision on the actions, and it does note and does not minimize the violation. Therefore, this court will take up the suggestion by Mr. Burt that during the remainder of this hearing, that the camera shall not photograph Mr. Robinson at all, and that will be the sanction of this court. I will allow the pool camera operator to reposition the camera to adhere to that. First, sir, I'm going to ask you to come forward because I want to make sure that's even a possibility. And again, I don't mean to put you on the spot. I'm simply, I don't want to set anyone up for failure. I don't want to make an order, and if it's not possible, then further sanctions could apply. And I recognize that it wasn't your anticipation to be on your own camera, but as it relates to not showing shots of Mr. Robinson for the remainder of this hearing, what are your thoughts?
I can do that. From where I'm positioned now, I can shoot this lectern, I can shoot the bench, and I can avoid the attorney tables altogether if that is what is desired.
All right. Do you need to do any repositioning of the camera to accomplish that? And I'm willing to give you that time to accommodate that, I just, again, I don't want to set you up for failure given what's happened. And so what are your thoughts?
No, I think the position I'm in, I am okay to avoid the attorney tables at this point and just shoot, this forward part of the courtroom.
All right. Thank you.
Thank you, sir.
All right. Turning to the parties, any clarification needed about the order of this court and the sanction that is imposed?
Your Honor, I only have one. It sounds like this issue is specific to video coverage and that the order not to take any imagery of Mr. Robinson would not apply, for example, to the still photographers. Do I have that correct?
Well, I'll hear from the parties before I offer that clarification. Do you wish to weigh in on that issue?
Just to indicate to the court that one of the problems is not just with the audio, with the video coverage, but most of the coverage is not covering the proceedings so much as close-ups of Mr. Robinson and comments about his demeanor. So if they catch him in a moment speaking civilly to his attorneys and he happens to smile, that then is twisted into evidence that he's some sort of a remorseless killer. So that applies to the still photography as much as what's going on with the video. So we'd ask the court not to permit still photography, at least for purposes of today. And I think after the court sees the motion, we'd be in a position to talk about the future. But I think for now, that's our request.
Thank you, Mr. Burt.
Thank you.
To the state.
Nothing further, Your Honor.
And any other inputs? All right. This court narrowly tailors its decision as to the violation, and the violation comes from the camera, the pool camera providing live feed. It doesn't come from the photographer. The photographer is the still, I don't know what the exact term is in this moment, it is eluding me, but the person who's operating the camera to take still shots is under the same requirements for this decorum order. I am not going to sanction them because what was before me with the 9-second clip and the 5-second clip doesn't apply to them. And so I'm going to limit the sanction as it relates to the pool camera photographer, again recognizing that the standing decorum order applies equally to the still camera photographer. Thank you, counsel. I appreciate you bringing this to the court's attention and the seriousness and professionalism that you presented this to the court. So thank you to all parties. And again, to the camera operator, do you need time to test out to ensure that there is any inadvertent capturing? I'm willing to do that. I just want to make it clear as day that Mr. Robinson is not to be captured in a sweeping shot in any form for the remainder of this hearing.
Understood, Your Honor.
All right. All right, counsel. With that in mind, how would you like to proceed?
The courtroom moved on. Proceedings continued, but something had already changed, not just for this hearing, but for how we understand justice in the age of constant observation, because this wasn't about guilt. It wasn't about innocence. It was about control of narrative. In a world where every movement can be clipped, slowed down, reframed, and monetized, where silence invites speculation, where faces become evidence, where reactions become conclusions, this hearing exposed a quiet truth that the courtroom is no longer sealed from the court of public opinion, that justice now happens under a lens that never blinks, and sometimes the most powerful testimony isn't spoken, it's interpreted. 14 seconds forced a judge to intervene. 14 seconds reminded the system that fairness doesn't just depend on rules, but on restraint. And the twist, the media didn't lose access. The defendant didn't gain permanent protection. No one was silenced. Nobody won. Instead, the system blinked just long enough to correct itself. And that may be the most human moment of all, because justice isn't loud. It isn't cinematic. It doesn't announce itself. It's fragile. And sometimes, to survive, it needs the cameras to look away. If this made you think, if it made you uncomfortable, that's the point. Because true crime isn't entertainment. It's responsibility. If you value careful reporting, measured analysis, and stories told without distortion, like this video, subscribe to EWU Crime, turn on notifications so you don't miss what matters, and comment below. Should cameras ever be allowed this close to a defendant? Your voice belongs in the conversation.